Okay, class, here we go. So we're going to do a little, I don't know if you want to call it a lecture or a supplement to this chapter 38 on relationships between principal and agent. We're going to embed this at the top of your chapter. So if you've got that page open, you could probably press play, speed it up or slow it down as needed, and then scroll through your content and hopefully have your bearings and understand the important things that you'll be tested or quizzed on for this chapter. Okay, so we've got so in this chapter summary, it's going to cover quite a few of the key points here. If you have that memorized and understand the terms in there, you're probably going to be fine on your quizzes and tests. But we're just going to go through this anyway. So we have, when we're talking about agency, we've got two main types of agent. For purposes of this class, the text originally had 5, but really the important ones are general agent and special agent. So a general agent is really unlimited in a lot of ways. A general agency is a way to say that somebody is acting on behalf of this other person and has all the authority needed to act on their behalf for just about everything. Generally, we don't want to give that kind of power to anybody except maybe a spouse. And so most of the agencies we're dealing with in this class are going to be the latter form, the special agency. In this kind of a situation, special agency is a synonym for limited agency. So they only have the authority to act within a certain set of parameters or for a certain type of transaction, or it's limited for a certain period of time. Okay. When we're talking about agency and the ability to act on the behalf of another person, we come into employee versus independent contractor situations a lot. A lot of times employers want someone to do tasks for them, and they'll either hire that person as an independent contractor or as an employee. Most state laws are going to try their best to classify someone as an employee if there's any room for doubt. So if the factors seem to be weighted one way or another, we're going to consider someone an employee rather than an independent contractor. So keep in mind, an independent contractor is someone who sets their own hours, they cover their own expenses, and then they will also have autonomy or control over how they do the tasks. They will, what else? They use their own means, usually their own equipment. So these are the qualities of an independent contractor, whereas an employee usually has the employer set the hours for them. Usually they're using the employer's equipment, and the employer has control over how they do the job. Some things, for example, in one of your quizzes, you might have a question about a traveling salesman, okay? And that traveling salesman is, usually setting their own hours. They kind of do things the way they want, so they kind of look like an independent contractor. But the thing to keep in mind there is travel expenses. So if they're being reimbursed, they're most likely an employee, whereas an independent contractor would cover their own travel expenses and incorporate that as part of their fees for their service. Okay. And then one of the ways we create these agency relationships, so we'd wonder, is it going to be, are we going to create this agency relationship orally, or does it have to be in writing? It can be oral. So for purposes of this class, there's only a few things that have to be in writing. Okay, that's going to be real estate sales or purchases, marriage contracts, or any kind of contract that's going to take more than a year to complete. There are some others, but for this class, those are the 3 to remember. Okay, everything else can be an oral agreement. So that includes agency. If you want someone to act on your behalf, you can have an oral agreement. Now, best practice is definitely to have that in writing, but it doesn't have to be. Okay. There's also capacity is going to come up a lot. So does someone have the capacity to make this agreement? Meaning, do they have the mental ability to make this agreement? Generally, yes, they do. They're presumed to have it unless we can show that they didn't. So if they had some kind of medical issue or the situation, such as prescriptions or other kinds of drugs in their system at the time, that may affect capacity. Age, if they're not 18 years old, they're also considered to be incapacitated. So there's a few things like that. So we have, throughout this course, we're going to have express, implied, and apparent things. Okay, so this is going to apply to agency, authority, contracts, partnerships, a few things. So we have express, implied, and apparent. So keep in mind, express is, in the terms of agency, it's expressly agreed upon. So we have a specific agency that we've agreed to do. Implied agency is implied by the situation. We're really not going to test on implied agency as much, but we'll test on implied other things in the future. So for this unit, implied agency most often comes up if there's, say, a minor child. They're deemed to have implied agency from their parents, even though they don't have the legal ability to make contracts and to be an agent for their parents. They're deemed to have implied agency, especially if they're shopping for basic necessities of life. And then apparent agency, or apparent anything else, is twofold. So first, we have to have a third party who's reasonably relying on this assumption or appearance of an agency. And then second, we have the principal, meaning the person who has an agent, has to be aware of that, or should be aware of that, and hasn't done anything to rebut it. So this happens most often if somebody is working for somebody else as an agent. There's a pre-existing relationship with a third party, and then the agent is terminated, but the third party has not been notified. At that point, the principal is deemed to have a duty to that third party to notify them. Otherwise, the court's going to say there was apparent agency. Okay, this comes up a lot. Read your text to be sure. Let's see, a couple other things. The duties of between agents and principals. There's a fiduciary duty that comes up a lot, and it's basically this duty to act in the best interests of somebody else. So an agent has a duty to their principal to act in their best interests. So let's say that my father has me as his agent under power of attorney. Okay. Now, while he has capacity, he gives me $100 a week just for fun. Okay. And that's his habit of his. He always does it. He does it for decades. And then he gets dementia, and I, as his agent, have to decide, do I keep giving myself $100 a month, or do I owe him? Is that part of my fiduciary duty where I can't do that anymore? And keep in mind, so in this case, it's not a substitute decision-making thing where I'm not making the same decisions he would make. That's not my job. My job is to act in his best interest. And is it in his best interest to give me $100 a month? Probably not. So, and it's not just because of self-dealing, right? If this was someone else, if he was gifting somebody $100 a month who's not related to me, has nothing to do with me, it's still probably gonna be inappropriate. Okay, so I'm trying to keep this under 10 minutes. So what I'm going to do is start another video and have this posted right below this one in the chapter.